agency in my riding, I wanted to convey to the members here the sense of betrayal the former Bill C-24 had on our sector and on the people that we served. In my role as executive director, I spoke at many citizenship ceremonies and worked with people as they prepared for their citizenship here in Canada. I was constantly overwhelmed by the immense sense of pride and dedication people felt as they prepared and finally became Canadian. It was events like this that really made me the proudest to be a Canadian citizen. This bill, Bill C-24, created a second class of citizen. In fact, it institutionalized systemic discrimination. It was a bill that was so unconstitutional, it had no place in our democratic foundation. Under the Charter of Rights and Freedoms, all Canadians are equal. It will be good to see this idea begin to be reflected in our legislation again. As our leader said in the 2015 campaign, a Canadian is a Canadian is a Canadian. During the last election, the NDP promised to repeal C-24, and I thank so much again my colleague from Van East who worked so hard to really make that happen, and I was very sad to see when all of those amendments were not heard. C-6 in its current form aims to rectify these missteps, but this bill does not do it entirely. After reflection, I'm mindful this bill is not ideal, but it will repeal some of the harmful and unconstitutional changes to citizenship made by the previous government, so I will support its passing in the third reading. While this is a step in the right direction, there are also many challenges that remain for immigrants, and we call on the government to take urgent action on lengthy wait times and huge backlogs, on family reunification and the barriers to citizenship that still remain in place. In the last session of Parliament, the NDP firmly opposed Bill C-24. We called on the Conservatives to withdraw it from the very beginning, but the Conservatives refused to listen. While some of the changes implemented by this former bill were in some cases overdue and addressed some of the deficiencies in the system, but others were so draconian that Bill C-24 was widely opposed by respected academics and experts in the field of law, including the Canadian Bar Association, the Canadian Association of Refugee Lawyers, Amnesty International, the Canadian Council for Refugees, and UNICEF. Mr. Speaker, during the time of canvassing across my riding and in the work that I did previously, I met many members of the communities I served, and I heard stories of people who were choosing to not venture towards becoming citizens because they were very hurt about this second class of citizenship. And many parents were very concerned for their children. One parent told me that his children had dual citizenship. He was choosing not to get Canadian citizenship, but he had married a Canadian woman and they had children that had both citizenships of his first country and hers. And now he's worried about how much their Canadian citizenship actually meant. He said to me, "My children live here. They will be raised here. This is the only country they will ever know as home. What if they do something and Canada decides to take away their citizenship? Where will they go?" Another person said to me, "It feels like the government doesn't want me to become a citizen. I now feel like I am a potential risk simply because I was born in another country." These stories illustrate the real fear that people are feeling and the total disregard for their dedication to this country of Canada. This Bill C-6 begins to make some of those changes, but it still leaves that hesitancy. It still has so many barriers to citizenship. It still provides too many things that create fear for members, Mr. Speaker. And I hope that this government will listen and take the amendments in the fall that my honourable colleague suggested and let us move forward in a positive way in this country. So, Mr. Speaker, I'm glad these provisions will no longer be law. Nevertheless, I am disappointed that Bill C-6 does not go far enough. It still allows a minister to revoke someone's citizenship without the right to a judicial hearing. And no matter how good their intentions, ministers simply should not have secret discretionary powers. Prior to Bill C-24, an individual who was accused of fraud and risked having their citizenship revoked, they could request a hearing from a federal court judge. A final decision would be made by the governor and council. Bill C-24 allowed the minister to make a decision based on a review of paperwork with no right to a judicial hearing. The Liberals' failure to address this feature in Bill C-6 means that there may still be a constitutional challenge for the Citizenship Act. The NDP believes that a citizen facing revocation should always have the right to a hearing before an independent and impartial decision maker as part of a process that considers humanitarian and compassionate factors. I remember the Prime Minister during the campaign talked about decentralizing the powers purposefully accumulated in the PM's office. The last government were concentrating power with their different omnibus legislations. What happened to the right to a hearing and to due process? Mr. Speaker, in my last job, I served many newcomers to Canada. Some of the stories I heard were sad, and the commitment to becoming Canadian, a country seen as free and inclusive, was tangible. The fact that the minister has the power to give or take away citizenship is a level of power that many people came to Canada to escape. Having a fair, transparent process is absolutely imperative. While this bill was studied at the Standing Committee of Citizenship and Immigration, the New Democrats proposed a total of 25 amendments. Only 2 of these were eventually passed, and I'm so grateful they were. The duty to accommodate for individuals with disabilities, and adding statelessness as a factor to be considered when granting citizenship based on exceptional circumstances. But the remaining amendments voted down weren't given reasonable, rationale to oppose by the Liberals. The Liberals also need to do more. The Minister of Immigration, Refugees and Citizenship has repeatedly acknowledged the considerable shortcoming of his ministry. He promised to take action on the long wait times, but we have still not seen a concrete plan. Now that this bill is in its 3rd reading, let us start to have this discussion in terms of how to reform it correctly. The minister should disclose discretionary grants of citizenship, the reasoning, and the frequency. There must be action on cleaning up the mess at Immigration, Refugees, and Citizenship, including speeding up family reunification, putting an end to lengthy backlogs, and removing the cap on parent and grandparent sponsorship. Faster processing times for immigration and citizenship applications, especially in light of the high fees paid by applicants who receive very poor service in return. And let me tell you, Mr. Speaker, the challenges that I faced in my last job would have tested the patience of any normal human being. The narrow scope of Bill C-6 prevented many amendments recommended by expert witnesses, including the Canadian Bar Association, from being admissible at committee stage. The minister has acknowledged this and suggests the Liberals will need to introduce another immigration bill in the fall to address these shortcomings. I certainly hope to see it. I would like to conclude today by urging the minister to work with us to table a truly comprehensive bill that will improve the Canadian citizenship process. It needs to happen, and it needs to happen soon. Thank you, Mr. Speaker.
Questions and comments. Question et commentaire. The Honourable Parliamentary Secretary to the Government House Leader.
Thank you, Mr. Speaker, and I appreciate the comments with respect to C6 from the member. And she made reference to a number of issues that are not only important to that particular member, but I would suggest to you by many members. I know a good number of members of my own caucus that aggressively pursue the issues such as processing times, backlogs, the restrictions that are in there. In fact, we found that one of the first actions by the Minister of Immigration was to speed up the processing times for spousals. It was to double the number of parents and grandparents being accepted in. We've seen huge processing time reduction in terms of citizenships. And I think there's going to be a lot more to come. The file in terms of the refugees and the Syrian situation that we've had, tens of thousands of individuals through that one category. I think the current minister has done an admirable job, a fantastic job in terms of just getting things done in a relatively short time span. My question to the member is, would she not recognize, even within this particular legislation, when it went to committee, we saw a Minister of Immigration that actually looked for consensus, and we actually had amendments that were accepted. And maybe if she could just provide some comment in terms of what she felt with respect to the amendments being passed that came from opposition.
The honourable member for North Island, Powell River.
Thank you so much, Mr. Speaker, and I thank the honourable colleague for his question. It's always good to see change, but this is the reality. Actions speak much louder than words. It's very good to say kind things. It's good to have good intentions, but until the action takes place, we have to watch that. So I will say to the member that it's been actually shocking for me. There's some good steps. Recently, after several years, I would say about 5 years of working hard with a local member in our community, we finally received some of her family members from Syria. That was a very positive move in the right direction. I'm glad to see that. At the same time as we're receiving people who, might I also add, mostly these 25,000 refugees that we have graciously welcomed, and I'm so glad they're here. Most of them came from the private sponsorship stream, not through the GAR stream, the government-assisted refugees, which was what I was hoping to see more of, so that we could allow those privately sponsored refugees to add to the wealth of the people joining our country. But we also saw a huge cut in services to settlement-serving agencies, about 6.5% in the area that I serve, and it was shocking to see that happening at a time when we need to serve these people.
Questions and comments? Question et commentaire. The honourable député, the honourable member. We just had a little bit. We've got to go back here. The honourable member for Vancouver East.
Thank you very much, Mr. Speaker, and I thank my colleague for her good comments. I wonder whether or not she would support this amendment, which failed at the committee because it was deemed to be inadmissible, and it relates to people who are deemed to be second-generation born. Effective April 17, 2009, Bill C-37, second-generation children born